I'm very happy to have a chance to talk with you tonight. It was something I really had to think about where your students are and how you might best reach them with some of this material. And so I've integrated into this talk some ideas for things that I think are interesting to get students to think about. First, let's talk about what are civil rights and where in the Constitution do we look for them? Well, I started with a very simple definition. The Legal Information Institute of Cornell says a civil right is an enforceable right or privilege which, if interfered with by another, gives rise to an action for injury. And then discrimination is, we talk about discrimination when situations occur in which an individual's civil rights are denied because of membership in a particular group or class. Now, some civil rights protections have come to be seen as required by the Constitution. Some are statutory, and some are seen as at the discretion of Congress. The Civil Rights Act of 1965 is an example of a statutory protection. So we still don't know, though, what a civil right is. And I want to give you a quote from a famous case called Corefield versus Coryell. Justice Bushrod, Washington Writing Circuit, wrote this decision. And by the way, I highlighted Article 4 because the documents that I gave you and produced, I made a mistake and it says Article 1, but it should say Article 4, Section 2, talking about the comity clause. And things that the privileges and immunities of citizens of the United States included protection by the government, the enjoyment of life and liberty, the right to acquire and possess property of every kind. It also included what we've come to know as the right to travel, which is one of the few rights that the court sees as a privilege or immunity of citizens of the United States. And they say, and he said, to which may be added the elective franchise as regulated and established by the laws or constitution of the state. So the elective franchise depends somewhat on the laws of the state. So there are many constitutional scholars that think this, which was not designed to be an inclusive list, but just illustrative list, are privileges and immunities that citizens of the United States have, and some folks have called these civil rights as well. We also look to the 14th Amendment, Section 1, for when we start looking for civil rights. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state in which they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. We talk about the three promises: the privileges or immunities, the due process of law clause, and the equal protection of the laws clause, which is the one we will be the most concerned with right now. Oops, all of a sudden that's not going anywhere. I need my slides are not advancing. What is going on? Kelsey, do you know how to make this work?
If you go down to the bottom left corner.
Yes, thank you. I'll do it that way.
There you go.
All right, let's see if I can still make this work. So there are three kinds of rights in the latter half of the 19th century. The pervasive understanding was that we could divide rights, and here you can think of the Jack Balkan handout I gave you. Civil rights, which is a right to civic equality, and these are the ones that are considered the most important. the ones that states have a duty to protect, and they include these: the right to make contracts. The Freedmen's Bureau made sure that newly freed slaves could make contracts and that they were fair. To own, lease, and convey property, to sue and be sued. These are central civil rights. Political rights were different, and they were lesser. So political rights, equal political rights, not all citizens have these. Women didn't have them, and they could be restricted. Native Americans didn't have them, and that was sort of less important. So that included the right to vote, the right to serve on juries, the right to hold office. These things could be restricted. Social rights, social equality. They're really not a great deal of claim that there's a right to social equality at this time, because it depends on the preferences and behavior of individuals. And the state generally doesn't get involved in enforcing social equality. If people don't want to sit together in railroad cars or places of entertainment, the state should not compel commingling. In fact, the state was enacting people's preferences when it segregated railroad cars, they said in Plessy. So Plessy versus Ferguson is famous more for Justice Harlan's dissent than for the decision by Justice Brown. But it's important to know that this was a case that people opposing segregated public facilities and railroad cars, places of entertainment, et cetera, they brought this case trying to overturn the Louisiana law. Obviously, it backfired on them. As I understand it, the first person that they tried to use to get thrown out of the white car passed for white, so they had to go find somebody else. But Justice Harlan, known as the Great Dissenter, is what we probably remember most about Plessy. And he said, in the view of the Constitution, in the eye of the law, there is in this country no superior dominant ruling class of citizens. There is no caste here. Our Constitution is colorblind and neither knows nor tolerates classes among citizens. Now, this sounds great, but what does it mean? Do we know what that means? Is it obvious what that means? The tensions that may be there in those remarks were probably not known to Justice Harlan at the time, but we've come to know them since. So one option is known as anti-classification. The Constitution is colorblind and bars racial classifications of all sorts. The Constitution, the law should not recognize race for any purpose. That might even include collecting racial data on the census, something that is a cause célèbre of one famous individual. Another option is anti-subordination. The Constitution opposes the maintenance of racial castes, group subordination, and second-class citizenship. If that's true, then perhaps there is some obligation on the part of the state or federal government to eradicate subordination and second-class citizenship. Justice Harlan, back in the civil rights cases of 1883, also talked about the badges and incidents of slavery. He talked about burdens and disabilities which constitute badges of slavery and servitude. And he thought that even the 13th Amendment authorized Congress to act. That is one view of the matter, that that we ought to eradicate all sorts of disabilities that flow from slavery. Now, in the aftermath of Plessy, where Jim Crow was then legally authorized in railroad cars and public accommodations and all of that, civil rights cases were part of that. We see a legal mobilization to dismantle Jim Crow. The NAACP, which was founded in 1909 by Black and white activists, worked very strategically and incrementally. How do you get the justices to see that separate is not equal in small settings perhaps that the judges might be familiar with? An example, Sweat versus Painter, 1950. The Supreme Court requires that Blacks be admitted to the University of Texas Law School, despite the fact that Texas had fairly recently opened a law school for Blacks within the boundaries of the state. The court found that the educational opportunities were not substantially equal. After all, members of the court were pretty familiar with law schools and what made them good or great. They said the University of Texas Law School possesses to a far greater degree those qualities which are incapable of objective measurement, but which make for greatness in a law school. That included the faculty, it included the library, it included the opportunity to interact with fellow students. It included many other factors, including the network of graduates to which someone might have access. That was one part of the NAACP strategy. I want to point out that other groups, including the Center for Individual Rights, have been working more recently to dismantle affirmative action in educational settings. The CIR recruited and selected plaintiffs for several key lawsuits, including Grutter and Gratz. And my point here is this happens all the time. Getting to the Supreme Court takes allies, resources, strategy, and some luck. And organizations concerned about policy issues, especially now that the Supreme Court can pick and choose its own docket almost fully, these organizations look for cases with the potential to advance causes. So this is a picture of Fred Vincent. Actually, it looks like a painting. He was the Chief Justice of the Supreme Court in 1952, when Brown versus Board of Education first came before the court. He apparently was opposed to striking down school segregation and died suddenly of a heart attack in September 1953. President Eisenhower nominated Earl Warren to take his seat. A month later, Vincent was sworn in as a recess appointment, and his confirmation by the Senate was the spring of 1954. And here is one of these things that, you know, I think is fun for students to hear. Felix Frankfurter was on the court at the same time, and Felix Frankfurter said this when this change of chief justices happened. He said privately that Vincent's death was the first solid piece of evidence I've ever had that there really is a God. He knew that having Vincent off the court made a huge difference in what was likely to happen with Brown versus Board of Education. Now, a bit of fun backstory on Earl Warren, because I don't think it does any good for students to think that there are just horrible villains and wonderful heroes in these stories. Maybe they need to think that first, but these are complex people. Even Harlan was adamantly opposed to the birthright citizenship for Chinese Americans, and he was in the minority in the case I wrote a book about, Wong Kim Ark. So as California Attorney General, Warren was running for governor in 1942. He was supportive of efforts by the Native Sons of the Golden West and the American Legion to overturn Wong Kim Ark. And federal courts rebuffed this effort to erase birthright citizenship for Asian heritage people born in the US. That's one bit of information. Earl Warren's, one of Earl Cray, one of Earl Warren's biographers, pointed out that the Japanese internment was partly the result of needling by Earl Warren, who kept urging President Roosevelt to do this. What is going on? Earl Warren was Dewey's vice presidential candidate in 48. He wanted to become president, but the two front-running candidates for the nomination, the Republican nomination in 52, were Ike and Robert Taft. Senator Nixon made it known that while pledged to Warren on the first ballot, he preferred Ike. Ike's campaign staff offered Nixon the vice presidential nomination if he could deliver California for Eisenhower. And it's not clear whether there was any quid pro quo to put Warren on the court if Warren threw his support to Ike, and Warren denied this. Ike did not use ideological litmus tests when nominating justice to the Supreme Court. Later, he referred to Earl Warren, his nomination, as the biggest damn fool mistake I ever made. By the way, he also was known to have said that Brennan, when he made two damn fool mistakes, Brennan was the other one. Another kind of thing to notice, I gave you a document on the government brief in Brown versus the Board of Education. While this has nothing to do with Earl Warren, it does have to do with how the government in 1952, during the Truman administration, pitched Brown overturning Plessy to the court. And if you look at that document, you'll see that there's a lot of Cold War rhetoric in there. The commies were making hay, they tell the court, by showing the United States to be hypocritical, talking about freedom for other people, but not practicing it at home. And that foreign diplomats were being treated terribly in the nation's capital and things like that. So it's interesting. Mary Dudziak has a book called Cold War Civil Rights that is interesting on this score. So in overturning Plessy, Brown held that separate educational institutions were inherently unequal. I won't read the quote, except that you get this famous remark about affecting hearts and minds in a way unlikely ever to be undone. And the Brown decision was probably the first time that the court looked at evidence from psychological experiments. And in that psychological experiment, Black and white children were given black and white dolls to play with, and even the Black children didn't want to play with the Black dolls. And this figured into the decision and that they wrote. I want to point out that a lot of people, including my own students, have a common misunderstanding about Brown. Brown required the dismantling of dual school districts, and segregation that resulted from state action had to be remedied, but it didn't simply command integration where the state had not maintained dual school districts. Now we did, and I will elaborate on that in a second. The fun thing to do, I think, is to talk maybe with students about how and how much did Brown matter. Gerald Rosenberg has a famous book called The Hollow Hope, and he challenges those who think that even landmark Supreme Court decisions make a big difference in American politics. He says, show me the evidence that the court really matters that much. So Rosenberg's claim includes some of the following. In the South, there was very little desegregation from 1954 to 1964. Little bit more in the marginal South. If people wanted an excuse or cover to follow the court, they did so. All deliberate speed in Brown 2 pretty much meant no speed. The Supreme Court alone could not affect social change without Congress, without executive support. And so we're reminded of Hamilton's Federalist 78. The judiciary has no influence over either the sword or the purse. It may truly be said to have neither force nor will, but merely judgment. So Hamilton pointed out that the court was the least dangerous branch, something that many people will contest. Now, it's true that Eisenhower was persuaded to send troops to Little Rock to desegregate Central High School in 1957, but resistance by courts, elected officials, and the public continued. And the case, a case would come to the Supreme Court that I'll speak about in a second. So continuing on, how much difference did Brown make? There was more desegregation of public facilities after the '64 Civil Rights Act, where the receipt of federal money was actually conditioned on compliance, on desegregating hospitals and other facilities. Did school districts have to deal with de facto segregation? What if whites moved increasingly to the suburbs and Blacks were concentrated in nearby cities? Could you achieve some kind of racial mixing across jurisdictions? The court eventually says, no, you cannot force busing across jurisdictions like that. The court had also released many districts from oversight by roughly 1990, which allowed some districts to backslide and stop their efforts. And also, the racial composition of schools and classrooms now looks about as segregated as it did in 1954. Over the last 3 decades, Black students have been increasingly segregated in intensely segregated schools. By 2016, 40% of all Black students were in schools with 90% or more students of color, somewhat less true for white students. And I put the source there for those statistics. Another bit of evidence, there were fewer white children attending public school after Brown. For a while, many were going to Catholic schools, but you saw the rise of the Christian day school and evangelical schools. This separates North and South, but you see that the South is enrolling more children in private schools even in 2012. So the population of white students in schools, public schools, has declined. On the other hand, with regard to the Rosenberg thesis, there's power in rhetoric, and Brown is considered not only an accessible decision, but it's a decision that is revered even as people disagree about what it means. It puts moral authority on the side of people challenging legally enforced segregation and added momentum to the movement for civil rights. These are only some of the yeah buts. So I think it's kind of interesting to talk about those things and see what students think. Is the court really powerless? If a landmark decision can't do better than that, what has Brown accomplished? An aside that I thought might be interesting for you. Cooper versus Aaron was the 1958 case that resulted from the Little Rock school desegregation battle. But there's an interesting argument among constitutional law scholars about whether the court claimed more than Marshall had claimed in Marbury versus Madison about the court's role in establishing the meaning of the Constitution. Is the court's reading in Brown the same thing as the Constitution? So some scholars talk about judicial supremacy dating from roughly this period, as opposed to judicial review. And these decisions in which the court says, we the court says it, therefore that is the Constitution, aren't just about race. This is from Cooper versus Aaron, that Marbury versus Madison declared it the basic principle. I'm not going to read this, I'm going to let you see it. But it follows that the interpretation of the 14th Amendment enunciated by this court in Brown is the supreme law of the land, and it's binding on the states. It's binding on every state legislator and executive and judicial officer, etc. So what we say the Constitution says is the Constitution. And here's the court as it consisted in 1958 in Cooper versus Aaron, where the court not only unanimously reaffirmed Brown and cited Marbury, but all the members of the court signed this opinion, which is extremely unusual. Those who were not present in 1954 wrote in this that they would have joined the Brown opinion. So they're trying to be as emphatic as possible. Okay, changing gears a tiny bit. So in Plessy's dissent in, Harlan's dissent in Plessy has many lives. Brown was seen as vindicating Justice Harlan's dissent. And every now and then a dissent becomes, when you say, you know, someday, you know, the court's going to reverse this or the country's going to rue this day. And they do reverse a dramatic decision like this. But the court has moved toward strict scrutiny in matters of race. In education, we see it in Bakke, where they said that it can only be justified by a diversity, but it must be meet strict scrutiny. Richmond versus Croson, Justice O'Connor writes for the court that even race preferences require strict scrutiny. This was a case involving minority business set-asides, where the court held that maybe the federal government has some power that the states were denied under the 14th Amendment. Shaw versus Reno, a redistricting case a few years later, O'Connor writes for the court that racial classifications of any sort pose the risk of lasting harm to our society. So I ask a couple of questions here. If there's been a history of legal disadvantage so that a minority group is unrepresented and has little or no chance of righting wrongs through the legislative process, if then the majority decides to disadvantage itself when those legal impediments are removed, should this new legislation be looked at differently? This is a question famously asked by John Hart Ely in Democracy and Distrust, an extremely influential book from 1980. And he thought that a majority should be able to disadvantage itself in order to make up for past wrongs. B, another kind of question. If women were excluded from voting, and even after that, few or no women were included in the legislature where measures chiefly affecting women were voted upon, are those measures potentially suspect? Well, Akhil Amar occasionally ruminates on this question. It certainly, those laws seem to be somewhat less legitimate, shall we say, than if there had been more than nominal or some kind of representation of women in the legislative body that made such laws. So another vehicle for civil rights, finding civil rights, we could say is Section 5 of the 14th Amendment, where it says the Congress shall have power to enforce by appropriate legislation the provisions of this article. Now, this, you'll notice, is this enabling language is in a number of amendments that follow starting in the 13th Amendment and following upon that. But what's this supposed to do? Does Congress have some latitude to define equal protection when passing laws? For example, in the Violence Against Women Act, which the court famously struck down part of, and affirmative action. Can Congress set out to make things more equal based on their sense that we are not equal yet? Could Congress, for example, work toward a goal of anti-subordination? If you remember the anti-classification versus anti-subordination readings of Plessy, could Congress say, we think equal protection requires anti-subordination and the elimination of castes? So is it a grant of power? It's a reasonable question to ask because recently the court has held that Congress can only act in response to a concrete violation that it is identified. That is, it cannot be proactive. It can't be trying to just generally improve things, shall we say. So this is an interesting development of where the court has been restricting what Congress can do under Section 5 of the 14th Amendment. Now I want to introduce a couple of other themes quickly because I have to pay attention to time. I gave you a handout that I've generated years ago on race, gender, and levels of scrutiny. For rights that are seen as fundamental, or for classifications that are seen as suspect, there we tend to see the court requiring the use of strict scrutiny. So while the court said in Grutter, strict scrutiny is not fatal, in fact, it usually is. I challenge my students to count on how many fingers is it going to take them to count the number of times the court uses strict scrutiny and the legislative measure in question survives. What strict scrutiny requires us to ask is there a compelling state interest in the legislative classification? Is this classification really necessary to accomplish a compelling state objective? And is the means chosen the least intrusive of rights that could have been devised? So sometimes the court may second guess legislators on what they might have done. Race is now a suspect classification. Bakke, Shaw versus Reno, Richmond versus Croson. And that is true whether or not the classification is considered benign or called benign or remedial, or whether it is invidious or insidious either. With regard to gender and rights, the court has never employed suspect classification. They talk about quasi-suspect classifications because there may be reasons sometimes why men and women would be treated differently at law. Women can have babies, and so far men can't. So these classifications are usually viewed under intermediate scrutiny. The questions here are, does the classification serve an important governmental interest? So the government has to give reasons, but they don't always have to be as vigorous. And is the means substantially related to the achievement of these objectives? It's a little more lax. I point out in my documents that in university, I'm blanking on the name of the case, the Virginia case, VMI case, the court moves to something called an exceedingly persuasive justification, which might be closer to strict scrutiny, but we're not there yet with gender. So let me point out one other thing, because you may, in some of your classes, I don't know, deal with classification on the basis of sexual orientation or sexual identity. So what about sexual orientation and the law? Justice Kennedy penned all the major gay rights decisions of the court from Romer through Obergefell. What's fun is that in striking down all those laws, the court used the lowest level of scrutiny, rational basis, for almost all of these cases. And the ones where they didn't, they just didn't indicate what they were doing. So I would say Lawrence versus Texas was a case where they didn't actually make clear what they were doing. So was there any rational basis for singling out LGBTQ plus people at law? Kennedy asks in Romer. If not, it must be animus, and this is an illegitimate state purpose. The law cannot stand. So there's plenty we could talk about there, but I'm just hitting on it very lightly. Another area where we can look for to find parts of the Constitution that are used for civil rights protection, believe it or not, is the Commerce Clause, which is Article 1, Section 8, Part 3, Clause 3. The Congress shall have power to regulate commerce with foreign nations and among the several states and with the Indian tribes. So everybody always scratches their head. Why the Commerce Clause? Well, part of the problem is that the 14th Amendment has been read to bar only state action. Now that's interesting because there are a number of people who think that the 14th Amendment Section 1 has a bunch of affirmative promises that privileges or immunities and due process of law and equal protection of the law are promises, and that the court has made a big deal out of the no state shall instead of the affirmative promises. Mark Tushnet at Harvard is one such person. But how do you get at discrimination that's not strictly caused by straight state action? Well, the answer for various reasons turns out to be the Commerce Clause is a very frequent tool to do that. It's made possible by the New Deal Court's expanded reading of the Commerce Clause from 1937 to at least 1995. I don't believe a single case of federal regulation under the Commerce Clause was struck down during that period. Does an activity have a substantial effect on interstate commerce? That's the question they asked in 1937. But when they say that, they actually are using a very low level of scrutiny, rational basis test, really, to look at that. Almost any reason the feds give is they will accept. Or does an activity have an aggregate effect on interstate commerce? The butterfly wings flapping. These are the questions that were asked during the New Deal era. And so with the expansion of the Commerce Clause to reach all sorts of activities, the legislators were able to hang even the Civil Rights Act on the Commerce Clause. Good portions of it depend on the existence of interstate commerce. So here are two examples. Heart of Atlanta Motel versus the United States and Katzenbach versus McClung, both in 1964. So this involves interstate commerce. There were billboards on the interstate advertising Heart of Atlanta Motel. It sat very close to the interstate. It pointed to the exit. A large percentage of the people staying there were coming from out of state because they had the logbook. The The 64 Civil Rights Act forbid racial discrimination by places of accommodation if their operations affected commerce. So the court held that Heart of Atlanta Motel could not discriminate because they were impeding interstate commerce. Is it the old movie, the not so old movie, a couple years ago, called, is it Green Book? Is that the name of the, that's the name of the film where the African Americans traveling in the South always travel with the little green book that tells them which places are hospitable to Black travelers. In Katzenbach versus McClung, Ollie's Barbecue in Birmingham, Alabama, is even a little further into the weeds. They went into the kitchen at Ollie's Barbecue and found out where the supplies were coming from. And about half the supplies were, the food stuff was coming from out of state. And so they held that Ollie's Barbecue was also covered by the Civil Rights Act, and Ollie could not consign Blacks to just getting takeout food. All right, I've got to stop, but a couple of questions for you to think about that are sort of backing up a step. How does thinking about the court's decision-making in these kinds of cases help students understand issues surrounding judicial activism and restraint? And I won't read all of that. And then second, how does a focus on some of these cases help students think about the relationship between the national government and state governments, and between privileges and immunities of US citizens and privileges and immunities that are up to the states to determine and protect? I believe I have one last slide, and that is some good sources. I think Quarrels That Have Shaped the Constitution is a wonderful source for students because it tells the stories about the people, the drama behind a bunch of individual cases. Peter Irons does too, although Peter Irons tends to focus more on First Amendment kinds of issues. But those are both very good books. And then for the teachers, definitely not for the students, because it's just going to be over their heads. Race Law Stories. It's a Foundation Press book, and it is not as lively, but it explains the law very well.